Good morning. We are starting our meeting 777. The topic today will be merger control around the world, current practice and trends in Europe, Asia, and the US. As you can see, we have guests from different continents. We have here Adam Biegel, co-leader of Alston Bird's Antitrust team in the US. Adam is also a member of Federalist Society's Antitrust Practice Group, and he is in the leadership of the American Bar Association section of antitrust law. We'll have Rita Motta. Rita is counsel in the Brussels office of Latham Watkins. Mrs. Motta has vast experience in representing clients in complex multijurisdictional cartel investigations and global merger filings. We have Mrs. Elsa Chen, co-head of the Allen and Gledhill Competition and Antitrust Practice and its public policy practice in Singapore. So as you can see, we have a guest from the US, Washington, DC, one from Brussels, another one from Singapore. Good night, Elsa. And we are glad that you are so late in your time and be here with us, sharing your knowledge. We are really pleased to have such qualified guests. I'm here moderating the event alongside my friends, Eduardo Frade, former Superintendent General of CADE. Eduardo now is a partner at VMCA Law. He is a guest professor at FGV Law program, and we have also Daniel Rebello, as a former general coordinator at CADE, partner in the compliance and antitrust practices of Pinheiro Neto. We are very glad for having these guys here, and looking forward for good discussion about what is going on in the COVID and in the antitrust practice during this pandemic phase. We have had several events covering the topic here, but they were earlier. We had discussed some topics before here, Adam, Elsa, and Rita, but nowadays we are deep, unfortunately, deep in the pandemic. So we have the ability to see things in hindsight too. Before it was just foresight. So we will be glad to discuss what is going on with you. Eduardo, if you may, I hand you the word to start the discussions.
I think we're actually giving the floor to Danny to make a few comments on what's going on in Brazil right now.
Sure, thanks Eduardo, and thank you, Victor, as well. We are indeed very excited to have you here. Thank you, Rita, Adam, and Elsa. We know we had to struggle a little bit with the different time zones, but we are very happy that it worked and that we are here and we can hear from you from the perspective of different countries and continents as well. Here in Brazil, we are discussing very important issues with respect to merger control. The unit is working. Actually, we heard that it's even more productive than it was before the pandemic. It's faster. But we had some important developments also in the side of the law. A new law 14010 was enacted on June 10, and it suspended the mandatory notification of certain kinds of transactions, including JVs. On the other hand, we are having a lot of discussions on cooperation between companies. Just yesterday, CADE set up a working group to try to discuss how the crisis protocol would work, and these notifications will move forward at CADE. So we are having quite a lot of changes here that we think are important. So to start to kick off these discussions, I would like you to tell us how things are working in your countries, and Rita in Europe and in other countries specifically as well. What is going on, how the authorities are working with merger control, how they are dealing with cooperation between competitors. And if we can start, I will give the floor first to Rita to tell us a little bit about Europe and some countries, and then we'll travel to Asia and then move back to the US. Rita, thanks once again for being here, and you have the floor.
Thank you very much, Vitor, Daniel, and Eduardo, for the invitation to join this panel. It's a pleasure to discuss merger control in COVID times with you. I think there's no question that the COVID crisis has had an impact on merger control in Europe from a pragmatic standpoint, or with timelines for review and other organizational measures, but also from a few substantive issues that I think will probably still influence the merger review post-COVID whenever we get to the post-COVID phase. And so I think I'll just, I selected 5 topics to discuss. And the first is just a very pragmatic one about practicalities. You know, in Brazil, we've been able to file electronically for years, but that was kind of a revolution in Europe. So, you know, one of the aspects that authorities had to get organized to allow electronic filings and then virtual meetings and etc. And then, of course, from a timing perspective, initially authorities in several European countries and also in the European Commission were encouraging the parties to delay notifications if they could be delayed. And then things, so, you know, but the notifications that are submitted are being reviewed normally. Just in the cases that I've experienced, in a couple of cases, there were some stop the clock decisions that I think in normal circumstances wouldn't have needed to be issued because they lasted they were very short, but, you know, I think it was just to also accommodate some operational difficulties that the case, you know, of, submission of documents and meetings and etc. And so, but that's the pragmatic point from the authority side. You had some countries that were postponing, actually suspended merger review timelines like Austria, but, you know, mostly it was this encouraging people to delay filings or, you know, trying to accommodate new circumstances in the ongoing proceedings. From the parties' perspective, there are 2 pragmatic points that I think are important. Once now people are trying to be more attentive and trying to accommodate in SPA clauses or contracts that are still being negotiated, solutions for, possible extensions of long stop dates and etc. because it's not until clear when predictability will increase. And another pragmatic point has been in some cases that are being reviewed now, of course, we are in the phase where parties need to conduct their business separately until they get clearance and they're able to close. But the crisis has had an impact on the target business that is often, causes the potential buyer at this stage or buyer awaiting clearance to need some information. And so we have been helping clients navigate, how to obtain the information that's necessary without gun jumping. Sometimes we contact the authorities to make sure that, that we are all clear on what's happening, but, it's understandable that they need more information. So we've been helping clients navigate this space. Now, moving to the substantive issues, I think one very interesting one is the debate around the failing firm defense. There has been a much discussed decision from the UK authority that approved Amazon's investment in Deliveroo, which is a food delivery platform. And the interest in this case is that initially the authority did not appear inclined to approve this. They opened a phase 2 investigation. They had just cleared the merger in the same space, recently. They were seeing this as a strategy for Amazon to go back to the market when they had exit with a similar business. But then the crisis made the Deliveroo business deteriorate apparently significantly very quickly. And so then the authority provisionally cleared the deal, considering that it was more harmful for Deliveroo to exit the market than to approve the Amazon investment. And so, the final approval is still expected, but that shows very clearly one successful application of the theory. And of course, in the distressed economy with, this is more likely to come up. What authorities in Europe have said is that they are, of course, open to reviewing these claims, but the standards won't be lowered because of the crisis. And so let's say the crisis is not a reason to approve mergers that will harm consumers. And so you still need, to really demonstrate that the business would have exited the market if it were not for the deal, that there were no less harmful alternatives because authorities will consider, for instance, if there would be alternative possible buyers or if the company could, for instance, benefit from some aid subsidy from the state that could solve the issue. So all these considerations are very much on the table. And another interesting aspect is not necessarily strictly failing from defense, but parties have been urging the authorities to to assess the merger, take into account the current market scenario. So parties that perhaps pre-crisis would have been very strong in the market in the view of the authorities now may have had, their competitive significance a bit eroded, or in any ways, the issue is that authorities are urged to even in the market consultations and etc., take into account the current market situation as well. And this could help avoid certain theories of harm. We know, for instance, that the EC is reviewing Air Canada's proposed acquisition of Air Transat, and in the market questionnaire, they asked for feedback on two scenarios. One considering the pre-COVID period, and then one considering how the market works under the COVID situation. So I think this is an interesting point to consider. Now, another substantive point is the scrutiny of buyers of divested assets. So even before the crisis, the European Commission was already requiring not only divestitures more than behavioral remedies, but divestitures with upfront buyers, which essentially means that you can only close after the authority approves the buyer. And then, of course, what the authority considers crucial to approve the buyer is normally, it helps to have experience in the industry, or in any events to have conditions to explore the business in a long-term basis, and also to be financially sound. But this last point, the financial viability of the buyer, has become, I think, has become a point of closest scrutiny to the Commission, at least by the European Commission, but I imagine at national authorities as well, beyond what was, useful, what used to be, or what I had seen. And so, for instance, we've had a deal where the buyer, potential buyer, was, experienced and had all the requirements, but then, because they had made a recent acquisition a year before or something, there were a number of questions related to the financial leverage of the buyer that were really detailed, and that, just show as an example that that's a careful analysis that the authorities have been conducting. The fourth aspect that I wanted to highlight is the review of foreign direct investments, and that touches a bit of the point of the political influence, political aspect that has become necessary to consider in merger transactions, even though not necessarily the competition authorities will review this, but then of course it's closely linked, right? And so in Europe, there have been concerns of, predatory acquisitions of assets that are essentially, that are very important for EU companies, so much that the Commission issued the guidance urging member states to either adopt this type of review measures if they don't have it yet, or to actively enforce them, especially if you're talking about current acquisitions in the pharma sector, for example, health industry, and then of course in other industries that are of a security concern. And so this is something that, when I know we'll speak a bit about forward looking a bit later, but that's something that I don't think it's going away soon. I think that's it's a concern that will stay. And again, to be maybe further discussed later, the fifth point that I wanted to make is the use of competition to promote or allow or make it easier, like environmental sustainability goals. This has been on the table for some time, but it's becoming more and more discussed. Not only for merger control purposes, but for merger control, of course, the point is that we don't have clear ways to quantify environmental gains or efficiencies in that sense. So whereas you have, when you're reviewing a deal, you would have measurable economic efficiency of other sorts, perhaps in the sustainability and environment, concerning sustainability and environment, not immediately, at least you have that, you're able to take that into account as much as it should be. And so there have been discussions in this sense, but then as I can explain a bit more later, not only in the M&A space, but also in other types of cooperation among competitors.
Thanks,
So,
Rita.
yeah.
Sorry, were you saying something?
No, these were the highlights from the
and quite a lot of highlights. quite a lot of highlights. Thank you very much for these insights. And of course, I think that we will have to develop new tools and new techniques to deal with this new world. Elsa, how are things going in Asia?
Well, I think Asia, as everyone knows, is where the COVID-19 first started, so we were one of the first to be affected. I would say that, when it really comes to antitrust, if you look at the whole history of development of antitrust laws in Asia, I would say that Asia is a very broad region that encompasses 48 countries overall, and most of the countries these days do have competition laws. But if you look at the history and evolution, I would say that one of the earliest countries to have competition laws in place is actually Japan, right after World War II in around 1945, 1947. But in terms of really enforcing and where it comes to merger control and the activity really started to pick up, I would say it's probably in the last 10 years. So, when you're looking at Asia, really the picture is one of, you're looking at, I would say agencies that are still quite new, where you compare to agencies in Europe and the US, for example. So I think but at the same time, I think what that history gives us is that we have the benefit of looking at how antitrust laws are enforced in Europe and in the US as well, and taking on board all these good learning points. So in these current circumstances of COVID-19, I think there are a lot of challenges for businesses. But what's interesting is that when you look at the public statements from the antitrust agencies in Asia, by and large, I would say with the exception of China, most of the other agencies have actually taken the approach of business as usual. It is this sense that in terms of having the tools to be able to assess mergers and acquisition in this climate, the agencies already have the tools in place. So instead, it is the agencies being very encouraging and constant reminders to businesses that they, even in the COVID-19 circumstances, businesses must still remember to comply with competition laws and comply with the merger control regime. There so far hasn't been this concept, again, with the exception of China, that there was going to be any exemptions given to certain types of arrangements or to certain sectors. So I think in terms of, again, because the regions are so diverse, we have a whole range of types of merger control regimes involving different types of thresholds, voluntary, mandatory, suspensive, non-suspensive. So I thought the other way perhaps maybe to talk through what some of the issues we're looking at in Asia is to actually look at it from the perspective of the M&A practitioner or merger parties when they're looking to do a deal. Even in the pre-COVID circumstances, as antitrust practitioners in giving advice, we are often asked three key questions. First question being, is this deal even a merger? Do we even need to consider merger control? And secondly, is the question of timing. What are the review timelines? Are there waiting periods? Is it suspensive? And the third point, of course, being the substantive review. Does this transaction, the deal certainty point, is this transaction going to give rise to competition concerns? Are we able to get this across the line? So I would say that by and large, even in the COVID-19 environment, these same three questions still exist. We're still dealing with the same questions. And in terms of the answers and responses to these questions, there are definitely some slight differences now because of COVID-19. So if I just take the point of the first question of, is this deal even a merger? Does it even trigger the merger control regime or not? So I think we're all very accustomed to the concept of, when you have a merger, you could have 100% acquisition, you could have amalgamation, business or asset transfer. I think those are very clearly in people's minds, transactions that could trigger merger control. But I think what we're seeing in this current environment is actually the other category of transactions that are not often immediately thought of as a merger and therefore triggering merger control. So some examples would be, say, your minority share acquisitions, your financing arrangements, your options to purchase shares, your joint venture type arrangements, and then just basically any other kind of situations that create a dependency on by one party on another party. I think what's interesting is probably in this COVID-19 environment, we're getting more questions about these other types of arrangements as well than your usual M&A. So minority share acquisition, for example, I think given the difficulties in doing due diligence, there may be, and I think the liquidity run that's happening for some companies right now, in terms from an acquirer perspective, perhaps they may prefer to test the water first with a minority share acquisition. And sometimes people get surprised that, look, if you're only acquiring shares of 20% and there aren't corresponding control rights, do we still need to do merger control filings anywhere? And sometimes clients get surprised when we tell them that, yes, you would need to do that in quite a number of countries, actually. So for example, in Japan, in South Korea, acquisitions of more than 20% shareholding, you would need to, it would trigger mandatory filing if your turnover asset value thresholds are met. In Philippines, for example, 35% shareholding, it could trigger a filing. In India, as long as you acquire more than 25%, and it's considered to be a strategic acquisition, you could trigger a filing. And by strategic acquisition, the bar is not high to cross. Essentially, if the acquirer has any part of its business that could be neighboring to the business area of the target, it's considered a strategic transaction, even at 25% acquisition. So at minority share acquisition, you would be trigger merger control filings in all these parts of Asia already. The other type of deal structure that people tend to get surprised at, and I think it could become more common because of COVID-19, is of course the joint venture scenario. I think we've seen a lot of pharmaceutical companies talking about entering into partnerships. And depending on what the partnership involves, is the setting up of a joint venture, then again, it could trigger filings. Now, using China as an example, let's say your joint venture is set up between a Brazilian company and a European company, and the joint venture was going to manufacture in Singapore. Now, if the parent companies have turnover in China that meets the Chinese turnover threshold, even though the joint venture is in Singapore, the parties will need to file in China and get the clearance before the joint venture can proceed. So these are some of the complexities when it comes to deal structuring that you have to manage from an Asia perspective. Now, let's say once you've worked through the deal structuring points, given the environment, what's the deal structure that best suits your needs, and you figure out where you might need to do filings, then the next question, of course, is, look, we have certain deadlines for loans coming up. We need to get transactions cleared so that we can complete it. What are the delay? Are there delays in review timelines? I would say by and large, when it comes to Asia, now certain agencies have become more cautious and say that we may delay the timelines. For example, Japan has put out a statement that says that we may ask you to delay your filing. But by and large, all agencies are committing still to the timeframes that they've provided for previously. The big question mark, of course, when it comes to merger review is third-party feedback. That's the part that affects the review timelines substantially, even in regular times. One of the difficulties and challenges we're seeing agencies face in this part of the world, might be common in other parts as well, is that because of the shutdown of businesses, it's actually very difficult to get the third-party feedback. So while agencies still try to keep to the timelines, we are seeing some slight delay because of the difficulties in getting third-party feedback. But otherwise, most of the economies have started to reopen the agencies as well. Electronic filing in Asia is generally possible. So that's also another way in which the agencies are trying to keep to the review timelines. So I think from a review timeline perspective, there's nothing to be too concerned about with Asia, but I think just bear in mind that there could be some delays, especially if situation on the pandemic worsens. The third point on the substantive analysis, I think just to echo some of the points that Rita raised earlier with respect to Europe as well. I think one of the common questions we get here as well is this question of the failing firm defense. To what extent can companies actually use that as a defense in the current situation? I would say that so far in Asia, so even before the pandemic, there have been firms that try to argue this. There are methodologies and guidelines in place by the agencies on how they would review a failing firm defense. And so far, what we're seeing that there hadn't been any major deals. We don't know if these are upcoming. Maybe the economic situation is still evolving. But the antitrust agencies, they're still keeping to their review methodologies. For example, one of the things that really need to be proven is that there are no other financing options and that this firm would definitely exit the market if the acquirer was not able to acquire the target. So just to also maybe touch quickly on China, which I said is some form of an exception to the norm in Asia. So what China, the State Administration for Market Regulation, SAMR, has announced is that a few things. One is expedited reviews for transactions in certain sectors. So they call these green channels. So expedited reviews for transactions in the industries that deal with coping with the pandemic or people's livelihoods. So for example, pharmaceutical manufacturing of PPEs, surgical masks, industries that are badly affected by the pandemic, and industries which are in general deemed necessary for the resumption of business. These could qualify for a green channel expedited review. The other thing that the Chinese authorities, I think since April, has said that they would do was that they give clearer guidance on what type of cooperation could benefit from exemptions from the anti-monopoly law. So again, it's tied to the pandemic. So for example, pharmaceutical cooperation type of agreements, though these type of agreements could benefit from an exemption from the anti-monopoly law under a public interest exemption. So that's where I think China is one agency that's quite clearly come up with pandemic or COVID-19 specific regulations, whereas most other parts of Asia is still trying to progress as they would as per usual.
Thanks, Elsa. And we understand that we gave you a big role by asking you to talk about Asia, but I think you did a great job. Actually, it's we got a bit of everything. Thank you very much for that. It's interesting to hear other perspective as well. I think you might be surprised to hear that in Brazil, minority acquisitions of 5% may have to be notified if the transaction has certain overlaps. So it's quite low as well. And we also have the benefit of learning a lot from the US and from Europe. Rita is actually from Brasilia. So she helped us navigating through these very different worlds as well. Adam, maybe you can share with us a bit of how things are going in the US.
Terrific. No, I'd be happy to, and thank you for having me today. I'm pleased to be here with all of my colleagues, even remotely, and I'm happy to talk about what's going on in Washington and in the United States, because there are some similarities to what my colleagues have talked about. I wanted to mention two large points about what's going on procedurally first in light of COVID, and then also talk a little bit about the enforcement priorities of the current antitrust agencies in Washington in this first segment. So my first point is that the antitrust agencies in the United States are still very much at work, like some of my colleagues have said about their jurisdictions. The merger filings in the United States, the Hart-Scott filings, have gone all electronic. The option was always available to us, but it was really not used very widely and now has become mandatory. And the agencies, like in other jurisdictions, are working entirely remotely. And that, of course, takes a little bit more coordination. I've heard agency staffers tell me it's a lot harder to move an investigation forward when you can't just walk down the hall and talk to your economist or talk to a colleague to bounce an idea off them. You have to schedule a Zoom call or find a good time to talk. So, but they are actually, both the Federal Trade Commission and the Justice Department Antitrust Division do remain very engaged. As a sign of sort of a slight return to normalcy, they had halted temporarily early terminations of the Hart-Scott waiting period. Within a matter of a handful of weeks after doing that, they allowed the expedited early termination treatment to be given again. So that's a good sign that they're getting back or got back very quickly to fairly normal. And in fact, they're seeing fewer filings because there are fewer business transactions. So they are actually able, I think, to spend more time on a smaller number of transactions so they don't miss antitrust issues and they get their competitive questions resolved on the deals that are on their desk. And our antitrust agencies in Washington have been very aggressive in issuing public statements to let people know that while the antitrust laws in the United States are flexible to allow pro-competitive collaborations and other efforts in the COVID era, and there have been certain business review letters granted in the pharmaceutical area, in the medical supply area on operational collaborations, the antitrust agencies are not going to give a free pass or stand down simply because COVID is mentioned as part of, say, a merger filing. Just like my colleagues said in their jurisdictions, the case law and the guidelines about what constitutes a failing firm defense are still going to be adhered to, and antitrust principles are not going to simply be discarded because there's a global pandemic. There was some legislative proposals to freeze all merger approvals in the United States during this pandemic period. None of those got any traction legislatively, so there are no legislative halts on merger clearances, and the same ground rules that applied pre-pandemic about even bankrupt companies trying to sell off assets still needing to go through the Hart-Scott-Rodino merger review process still is in place. So even actually distressed assets that have gone through bankruptcy still need to go through an antitrust review. In terms of what it's done to the timeline, like my colleagues have said, in the United States, the FTC and DOJ have both said this will add some more time. So they are asking for additional 30-day extensions under timing agreements and some pull and refile scenarios. But the FTC issued a very strong statement early in the crisis saying, if you don't give us those voluntary extensions, we will not hesitate to go to court to litigate to freeze a transaction. So, they're making very public their desire to get voluntary extensions to accommodate the COVID inefficiencies in process. And both agencies have continued to bring cases in the COVID era and reach settlements. In the FTC, in industries ranging from coal mining to hospitals to e-cigarettes and pharmaceuticals, and the Justice Department in the Sabre Farelogix case continued to be appealed and resolved, as we all know. There are divestitures approved in the dairy farm area, defense contractors, and deals abandoned in the book publishing area due to those ongoing investigations even during this COVID era. And I'd be remiss if I didn't also point out that our state attorneys general, who have independent enforcement authority to bring challenge anti-competitive mergers, certainly are also not asleep at the switch. The final opinion was rendered in the Sprint T-Mobile case, and the deal was allowed to proceed even during this COVID era. And I think that challenge by the New York Attorney General and a number of others is a signal, as we're going to talk about future predictions, that attorneys general may still be active in challenging mergers when the federal enforcement authorities in the United States decide not to bring a challenge. In terms of substance, I do want to make a point that, as I think we all know, in the United States, our two antitrust enforcement agencies, both are, I don't want to say controlled, but they reflect the party in power in the White House. In our Justice Department, because it is run by political appointees confirmed by the Senate and appointed by political leaders, as well as in the Federal Trade Commission, where a majority and the chairman are appointed by the current occupant of the White House. Many people mistook that early in the current Trump administration for sort of a hands-off, laissez-faire approach that it would be likely. But the reality, I think, has been very different. Both agencies are still very heavily engaged in policing anti-competitive conduct, including anti-competitive mergers, and in fact have investigated and gone after a number of issues that you would not expect to see prosecuted in a more hands-off environment. They certainly have kept their hand on the switch in hospital mergers at the FTC. which I think have become even more important in the age of COVID. The debate about do we need more capacity, more competitors, or bigger hospital chains to serve the American population. We certainly have seen bipartisan interest in both agencies involved in the tech investigations, which include retrospective looks at technology mergers and acquisitions of nascent competitors by the FTC. We've seen investigations at the Justice Department into minority investments. We've seen both agencies promulgate revised guidelines drawing attention to vertical mergers, which the chairman of the FTC said should not be considered presumptively pro-competitive. That process got a little bit halted by COVID, and so the guidelines have not been finalized. But I think, as we all know, the Justice Department was very aggressive early in the current administration, challenging the AT&T Time Warner transaction. And even though they did not prevail, the issuing of guidelines, I think, will help them bring future vertical merger challenges, whether it's in telecommunications or even more likely in the healthcare area. And I'll also add, there has been, I think, a market increase in creativity also with our antitrust agencies. At the Justice Department alone, over the past few years, they have brought out some different tools. For example, the Justice Department actually used a binding arbitration to try to efficiently resolve a merger investigation, where they appointed a private arbitrator on a single issue of market definition that would be binding, rather than going to court and litigating this and appealing it. That was in the Novella Saliras transaction, and I think the Justice Department was very pleased, not only because it turned out their way, but very pleased with the efficiency of that result, and so they might actually use that in future transactions. And they've also been very active in the Justice Department on policy advocacy, weighing in a variety of private cases, including a privately brought merger challenge in the Fourth Circuit involving door makers, where they weighed in about the private rights of action for private parties to challenge mergers. And I think one other substantive comment, and I could talk a little bit more about it as we talk about predictions for the future. There is a lot swirling around the politicization of antitrust, or possible politicization of antitrust in the United States. Traditionally, we've thought of antitrust in the United States as fairly apolitical, even administration to administration. But in the AT&T case, there certainly were allegations that it was a politically charged case because AT&T was that transaction involved CNN, which was not favored by the White House. But I think there was no evidence put forward during the litigation of that case about interference from the White House. But ironically, today, I think at this very moment, there actually is a hearing in the U.S. House of Representatives where a senior staff member from the Antitrust Department is testifying about his perception that the Justice Department investigated mergers in the cannabis industry purely for political reasons coming from the Attorney General's office. So there was a lot of talk in Washington about the priorities of merger enforcement, but I think in the mainstream, a lot of it are things that you would see by an independent enforcer trying to juggle all of the antitrust docket that is coming across their desk and making some fairly mainstream decisions about mergers to monopoly and reacting to consumer and market pressures to try to make the right decision to protect and promote competition. That's sort of an overview about antitrust still being alive and well in the United States, COVID or no COVID.
Thank you very much, Adam. Thank you, Elsa and Rita, as well, for these very interesting explanations. I can definitely see that some of them are very familiar to some Brazilian discussions. Other, of course, are more specific of your jurisdictions. But in a general sense, I have the feeling that all antitrust authorities are sort of debating the same core themes regarding this current phase of merger control during the pandemic. And as you have all raised already a few questions regarding that, we of course start to think about possible trends for the future. We are seeing right now that the way authorities are dealing with the pandemic and the competition effects coming out of this is already bringing up possible trends and possible future changes regarding merger control by antitrust authorities. So just to give a few examples, for a variety of reasons, we have seen prices exploding in certain items. And this, of course, draws a lot of attention to the antitrust authorities and puts pressure on them on how they should deal with this. Another issue that calls a lot of my attention has to do with the fact that all of a sudden, countries realized that they were very much dependent on foreign imports for certain essential goods. So to put this into an antitrust perspective, we used to have a worldwide relevant market for certain goods, and overnight, because of the pandemic, they became national-wide relevant markets. And countries started to realize that they weren't able to get surgical masks, for instance. And this, of course, raises a lot of issues, industrial policy issues. This brings out nationalist talks. This brings out talks about how maybe free trade has certain problems that need to be dealt with. People don't like the fact that when they need an essential good, they certainly see themselves out of it because they are dependent on imports and such. As antitrust practitioners, of course, we, at least I can speak for myself, tend to enjoy or defend the fact that competition might be a worldwide scenario, and goods should compete from one country to the other, and that foreign companies should compete with domestic companies and so on. But all this that is happening brings out these subjects, and there are real questions here to be answered. Just to give you an example, I'm going to read out to you an MLEX piece of news that was released just a couple of days, but there were others such as this. And the headline goes, "Push for strong EU industrial policy vindicated, say Altmaier and Lemaire." We're talking about here a German minister and a French minister. The EU's executive arm is getting behind a push for a strong industrial strategy for the bloc and protection for strategic businesses from competition threats from China and the US, the German and French economy ministers say. And more than that, they actually use the word and start talking about creating European champions. And we know this has been a policy in some countries, and it's there are people who defend this, there are people who really attack this. But of course, this entire situation that is going on now sort of raises the issue about these people that defend European champions, or that defend American champions or Brazilian champions and so on. And of course, this has an effect on competition discussions and merger control. Should antitrust authorities be more prone to accept national champions and to accept industrial policies that realize or that defend that maybe we do need to have some domestic strong companies in certain areas? And how does that impact antitrust-wise? These are just a couple of examples, but of course, feel free to talk about other future predictions that you may have and see as trends coming out of this pandemic. Since I started giving an European example, I think it's only fair to give the floor to Rita first.
Yes, thanks, Eduardo. Well, the article, the declarations that you read are very much on the table since the Alston-Siemens merger was blocked. There was, you know, the member states involved in that they were, you know, did not agree, and there was since then a lot of discussion about, you know, whether you should really have these industrial policy concerns to have, you know, to ensure that Europe has a self-sufficient industry that is able to compete properly with the foreign industries and not being threatened by the lack of supplies or etc. And okay, there is a debate in between whether all the interests of which member states would be at play depending on the industry, but the fact is that that was on the table. And even though the competition law, the competition decision in that case did not take on board necessarily these comments, the fact is that with the new commission, this has been debated. There's an ongoing debate in the industry policy as an industry policy portfolio, not necessarily related to competition law, even though we know that things end up being interrelated. Of course, from a competition law perspective, whenever the European Commission or national competition authorities will analyze in a merger potential buyers for assets, they can already favor more or less, foreign or domestic alternatives. But what shows that this is very much on the table is this very recent consultation that the European Commission just launched, the white paper, to assess what tools can be used to address potential competitive advantages of foreign companies due to foreign government subsidies that they can receive, right? And so that's another way where the Europeans are trying to find tools, and the white paper has a few alternatives to consider. But the issue there is, how do you take account of the advantages that that companies can receive outside of Europe, even if they for instance, have a presence here and try to make an acquisition through the European subsidiary. How do you take into account the subsidies that they may receive outside? And so this is ongoing. I think until September there will be this consultation, and there will be a lot of debate on this still going forward. So yeah, I agree with the issues that you flagged, and I think these issues have been exacerbated with the crisis, but they will continue to be addressed and be necessary. There will be reflection, and some measures will be taken even post the COVID crisis, I think, on this.
Thank you, Rita. Elsa, how about in Asia? Is the national champion debate a debate in the countries over there? And aside from this debate itself, do you predict any future changes going on in the regimes of merger control over there because of lessons that are being learned during the pandemic or feelings that are being raised during the pandemic?
Yeah, so I think, Eduardo, you raised a very good question. I think with the pandemic and the disruption to the supply chains, it's really causing a lot of governments to, rethink how things have been. Have we all gotten too comfortable with feeling like, the existing supply chains were reliable, and not really thinking about how a global health crisis like this could have such wide-ranging impact. So I think when it comes to the question of national champions, I think interestingly for me coming from Singapore, I think Singapore's approach has always been one that we are part of this global economy. Globalization is important to us for Singapore. Just in the past few weeks, our government ministers have also been on the television broadcast talking about how important global trade is to us. Now, that's the overall government policy perspective for Singapore as a trading hub to really be able to continue doing well economically. We need the global supply chains to continue. But I think one thing that plausibly might evolve or come out of all of this is the concept of perhaps more regional hubs. So I don't think it's going to be a shift of completely, we are going to rely on global supply chains. So now we're just, at least for Asia, to completely relying on just domestic production. I think the idea is probably going to be more of regional supply chains as well, and diversification in that manner. So when it comes to antitrust review then, in terms of a definition of a global market versus a national market, I don't think it's going to be a case where it's entirely changed from global to national, but regional will still have a part to play. The thing that I think just coming from Singapore and observing how our own antitrust regulators have tended to assess the situation, again, given our unique place in the world, is that, again, from the regulators' perspective, they do feel that whatever tools they need to do their assessment and analysis, and at the same time try to protect the competitiveness of the economy, those are tools that they already have. So very often for us, for merger reviews in Singapore, even where the case is being argued as a global market, the commission does take a view that, well, yes, but we still want to know what local market shares are. We still want to know what the competition conditions in Singapore in the national market would be. Very often it's a case of, while we may agree that the market could be defined globally, but if the national market is a plausible alternative market definition, they just want to review all of that and exhaustively conclude that, well, whether it's global or national, there are not going to be issues. So that has been the analysis so far. I think that's a trend that will continue and perhaps also become very important given the current situation and the learning points that lessons that we're learning from the pandemic. I think that just building on from that, the other thought that I had was that, I mean, if you look at the antitrust laws as they're currently structured, I think there are quite a number of jurisdictions which will say that, well, when we assess a merger, we're going to look at net economic efficiencies. We're going to look at, are there any benefits coming out from the transaction as a countervailing factor to any lessening of competition that might arise. But very few jurisdictions that all actually have something specifically called a public interest exemption. So exempting something because it's a public interest or blocking something because of public interest. So I think the thought that I had is, you know, as we're seeing how, in terms of what is defined to be competition, is evolving as economies evolve and as business models evolve. Like, for example, you know, data in the past didn't used to be such a big thing, but now it's so important. It's considered as the price that consumers pay, and if a lot of things then it's seen as a sort of a price increase. I think what we are going to see is this evolution that, you know, even if there isn't going to be a specific public interest consideration that's built into the regime, what I think we need to be prepared for is that, you know, what are the key pillars of what constitutes competition? I think that may change. So, for example, if now we're looking at competition in terms of price, quality, output, I think innovation is going to be a very big thing. Is a transaction, and we're already starting to see that. So is a transaction going to lessen innovation? Is it a killer acquisition? Is it going to take out a player that's going to bring about new developments in the market? You know, those factors of competition are constantly changing. So I wouldn't be too surprised if in future, one of the factors of competition in terms of assessing the quality of competition becomes, well, do we have a sufficient range of competitors out there? Does this transaction lessen the range of competitors, and the range being that global as well as domestic competitors? So I think that's something to constantly watch out for.
Thank you, Elsa. How about you, Adam? Do you foresee any changes in the future of antitrust in America?
Sure, it's just a simple answer, a yes or no, right? Right, Eduardo? No, I do think there are a number of things that are percolating in the United States that we may see changing a little bit as time goes by. One I'd say more philosophical. I think much like Elsa and Rita had said, the COVID era, I think, is going to affect perhaps how parties and agencies think about consolidation. You know, antitrust has always been a predictive exercise, and I think it's going to get even harder for the agencies perhaps to predict future developments, because if they're trying to predict in a straight path the way the economy may develop and the competitive pressures that may exist, I think we're learning right now from our current experience that it may not be a straight line, And so I think parties are more inclined to argue about the need for size or diversification, or the inability of the agencies to predict the unpredictable. So I think it's going to affect the advocacy strategies of the parties as they are challenging the concepts of anti-competitive effects and market definition. I mean, do we have to always consider what would happen if everything went online as a potential secondary market with its competitive effects? I think the other thing I wanted to mention is I think the groundswell going on in the United States about potential changes in the antitrust laws, because even before COVID, there was a lot of interest and debate about whether the antitrust agencies and antitrust law was appropriately applying the long-held consumer welfare test in the United States. Looking at prices and looking at overall consumer welfare, because there's been a lot of debate, what some call hipster antitrust, that other factors should be brought into the mix, whether it is labor concerns or privacy concerns or national security. And although they have not taken hold in sort of current antitrust enforcement priorities, I think you're going to see perhaps a lot of potential shift if there is a change in administration, because with a change in administration, you could actually have legislative adoption of changed burdens of proof or sectoral presumptions or bans on mergers of certain sizes. If there were, say, a Democrat in the White House and Democrats controlling both houses of Congress. And certainly the attorneys general in the various states that I mentioned were active in the Sprint T-Mobile matter, are elected officials and often may travel under state antitrust law and have different priorities. So I think there could be a lot of shift depending on the results of the elections this fall in the United States for antitrust law, because this is the first time I think in many of our careers that antitrust law has been a very populist topic. Raised both by Democrats and Republicans because there's more attention, I think, in the popular discussion about large companies and the importance of having competition to benefit consumers.
Okay, thank you, Adam. Thank you guys for the very good topics that you raised. I like it very much the last presentation of Adam. As I see here, and it looks like that it's really alike in the US, and I would bet that it is not that different in Europe, at least. I don't know Singapore for sure, but we are used to people who study antitrust and practice antitrust, we are used to live in kind of a neutral ground with our own rules, with an orthodoxy that almost everybody follows. And we have seen in the last years, like the hipster antitrust movement, or in Brazil, it's quite common for people to ask for decisions that should take into account effects in the labor market, for example. But up until now, it was very clear that antitrust has his own set of rules and must follow them apolitical in kind of a neutral ground. But as a matter of fact, as we live in an age of ever more big companies, people are looking at antitrust with other eyes, and the tech companies made this pretty clear for everybody, and the pandemic in a more acute way. We have companies under stress, preoccupations about the security of supply chains and so forth. So as I see things, the main topic for the next years maybe will be how antitrust will maybe take a more central place in the economic debate. And this obviously will lead to some discussions in a political fashion, as Adam is saying. So we see authorities, and I think it was Rita that talked at the beginning, authorities always talking, and in Brazil is the same way. We won't lower our standards in the pandemic, but which standards are they talking about? The usual standard, the standards that I would say orthodox. I don't know if the antitrust orthodoxy will survive the pandemic for a number of reasons that were already underway. The preoccupation with big companies, the hips and antitrust movement, the growing relevance of antitrust in political debate and so forth. So it's really something that make me think about, which is how this will happen. You know, how this realignment in this the things will play out. Most importantly, how this will play out at the political stage, without antitrust being so apolitical and neutral things as it was used to be. But I will handle the word to Eduardo again to another set of questions. Eduardo, please, you have the word.
Thanks, Victor. I'm actually gonna get the. I'm gonna ask a question that has to do with what you just said. So we're talking about future predictions and changes that might occur, some of which are very much influenced by political influences, and I don't say that in a bad way. I mean, some of them are actually much needed topics that need to be discussed. But my question is, do our current antitrust laws and guidelines and doctrine even have the tools to execute some of these ideas? I mean, even if an authority was to start believing that national champions are important for some reasons, or that antitrust should absorb some of these political trends that are being brought into the debate, do the current laws and practice and guidelines, would they allow for the antitrust authority to approve a transaction that they, based on the fact that we're talking about domestic companies, or reject a transaction based on the fact that we're talking about foreign countries? This particular set of reasoning seems to me like something that is not currently part of our antitrust laws. Will we need the laws to change, or is there room to work with these changes within the framework that we already have? Adam, Rita, Elsa, feel free to talk about this if you want to.
And Edu, if I may add to your question, should they change? Are the authorities,
that's a good point. Yeah.
Is the competition authority the one that should handle these matters? Is the competition authority the one that will have the necessary focus and tools, or will they just lose focus on what they're currently doing and the job will not be done? So it's a great question. So sorry to jump in, but
it's a really great.
Just to add
may I join too? Just with a small comma. Do they have the choice to do this or not to do this?
Just one quick thing. I realized that Adam disappeared right when we asked the tough questions, but that's fine. There he is.
No, I'm here, Eduardo. I was just trying to keep my connection as stable as possible.
I don't want, well, I can quickly react. I think, well, there are several issues that we are discussing, right? What should be considered consumer welfare if you think about the environment and data and etc. And then the issue about protecting national industries, or getting into a trade war, how to ensure protection against all this. To begin with the customer welfare issue, for instance, the debate now ongoing on environment and sustainability goals. The Commission had a public consultation until February open about the horizontal guidelines, the ones that the block exemptions for corporations between competitors. And one of and there were many comments made in the sense that, you should really, there's a lot of clarification needed about how competition law tools could help promote this type of cooperation. In this case, I think the existing tools would be sufficient, but they were never thought to be applied like this. And so there's a disconnect between all the circular economy goals, climate change goals, all the pro-environment goals that all governments have been setting, and how you can get there, and how competition law can be applied to allow cooperation, to reduce, for instance, to overcome the first mover disadvantage, to help quantify these types of benefits that are not necessarily strictly economically quantifiable. And so there's a lot of debate going on, and for this type of issues, I think you just need to take it maybe to the next level to try to apply the rules that are there. For the industry protection and etc. Well, I'm not sure competition rules are enough, and so the second type of rules of foreign investment control have been developed, right? So my job until last year or 2 years ago was, we analyze what are the merger control thresholds around the world, and now we have to do twice. So we have like 70 or more jurisdictions, and now we have to consider merger rules and foreign investment rules. It has not become simpler from that perspective, because now you have this additional wave of rules that you need to take into account with there. And the issue is that the national interests or the thresholds that the foreign direct investment rules try to protect, or the way they try to do it, they vary enormously within Europe, among the European countries, and then at global level as well. So there's a lot of, this is clearly developing. I think in Europe, for example, at least half of the member states have these laws, but the expectation is that in the next 2-3 years, there will be general adoption of some type of foreign investment control. And yes, and now they are considering, again, thinking that maybe the existing tools are not enough. There's this ongoing consultation about how to create a tool to help protect, facilitate, or ensure that European industries are able to compete with foreigners that have subsidies, for example.
Elsa, any thoughts?
Yeah, so I think coming from my perspective, I think that for some of the issues that are being raised, the current rules are sufficient to a certain extent. So if you look at whether to approve a transaction, so again, you have to test that, okay, does a transaction substantially lessen competition? But even if it does, there are other factors that you can consider to grant the approval for the transaction. So like the net economic efficiencies point, some jurisdictions allow other economic benefits to be taken into account, or in some places, public interest. So it's more of a, if you were going to block a transaction, there may be certain carve-outs that, for other reasons, you might want the transaction to be cleared and to go through. Then there are some tools which are currently allowed under the competition laws already. But it's more the other way around, that if the transaction wasn't going to give rise to a competition concern, can the antitrust authority block the transaction, and then on what grounds? Then I think under the current antitrust rules, there isn't something that allows for that, unless you take, I suppose, a very dynamic interpretation of what competition really means, and what you're really trying to protect when you say you're trying to protect competition. Again, in the past, very simply, we looked at price, we looked at quality, we looked at output. Now we're throwing more factors into the mix on what competition is meant to protect, like innovation, data being important as well. So I do see that antitrust laws can continue to evolve within its current framework to take into account things which can properly fit into what constitutes competition. But for something that goes beyond that, then I think the current rules just don't allow for it. Now, on my views of are these factors important? Personally, I believe very strongly in all the ESG criteria. I think these are important things that everyone should take note of. I'm not certain that's something that falls within antitrust rules entirely, but that's not to say that there shouldn't be a separate rules that apply to it. One of the things that we're seeing in Singapore, just to mention that, and interestingly linked to COVID-19, is that because of the difficulties that COVID-19 has brought about, in the real estate sector, tenants in Singapore are actually facing issues, and they're arguing that landlords have an imbalance of bargaining power and were able to impose unfair terms. So is that something that's important to the economy? Probably very important. The government is very interested in it. And the Competition and Consumer Commission in Singapore is now undertaking a market study to study whether within that space of real estate, is there really an imbalance of bargaining power? So in some part related to competition, in other parts not. But interestingly, maybe in the next few years or months to come, we may see the Antitrust Authority in Singapore take on an additional role to look into the tenancy space that isn't within antitrust, but looking at important issues under a different set of regulations. So I think with the expertise that antitrust regulator may have, they could take on additional roles, provided that that's the direction that the government policy is going.
Adam, what do you say?
Sure. I think in the United States, there's been a tradition of, I'd say, modesty, jurisdictional modesty by the antitrust agencies to not go beyond the corners of pure competition. The way the United States analyzes foreign investment, I think, is an example, because there is an entirely separate body, the Committee on Foreign Investment in the United States, that is made up of security consequences of foreign investment. And traditionally, that has been a very separate endeavor from what the FTC and DOJ have done, in part because there was a belief that the agency should stay to their area of expertise, just like the Federal Communications Commission or the Transportation Department might get input from the antitrust agencies. They should not be the decision maker on very specific sectoral regulation where there are other experts and other considerations to take into effect. And that has become the national security sort of apparatus through the CFIUS process has become larger, as I think we're all aware, and gone beyond simply the very narrow definition of critical infrastructure to be including a lot of other concerns. I think, though, as I mentioned, there is more pressure to consider other non-traditional concerns under the antitrust umbrella. And I think practically sort of doctrine and dogma. For example, even under the current Republican-led Federal Trade Commission, it was no secret that almost every merger investigation was being asked to focus on the consequences of a transaction on labor markets. It may have been a brief discussion, but it was something that even the current Republican-led FTC was directing staff to look at. What is the impact of this, not only on prices and number of competitors, but the labor force, specialized or unspecialized, in a particular deal? How will it be affected? And that can certainly change the dynamics of how private parties analyze mergers, present mergers, because as we all know, most transactions don't get to a challenge phase. So you usually want to address concerns and avoid them at a more ordinary day-to-day level. And that can affect the deals that are being made and concessions that are being made. I think if the antitrust agencies wanted to actually litigate, on the basis of, I'd say, a non-traditional competition factor, it might be much harder. As we saw in the AT&T Time Warner case, one of the reasons the federal court said, I'm not going to block this transaction, is because they said, we haven't seen you do this before. You haven't articulated guidelines in the past 25 years on it. So I think it would be a risk in our sort of common law case precedent system for a sort of out of the blue attempt under current antitrust statutes to be sort of doing an entire pivot. And so I think, some additional guidance, like they're doing the vertical merger guidelines, perhaps could, help smooth that path, so they didn't sort of run into a brick wall with new and novel theories that had no case law supporting them. But which is why I mentioned the legislative proposals really, I think, as Victor was saying, can change the ground rules. If there were a legislative mandate amending our antitrust laws saying, this is a viable theory, or this is the new basis upon which things should be reviewed as part of the substantial likelihood to reduce competition, that changes the ballgame. Then you don't have to argue about, have I done this before, if you've done a legislative solution. So I think there are going to be a number of fights about this, this growth of the bases for merger control enforcement actions. And as I said, many of them may depend on the outcome of our country's elections in the fall.
Okay, thank you, Adam. It was a very good presentation. So we are heading to finish the event. It was really nice opportunities to talk to you and see what is going on. I guess that for what I heard here today, at least at the worldwide level, there is some kind of consensus on some directions that we shall take in the future. It shows that at least that we have a body of academic studies and intellectual approach to the matter, that it is not that different from country to country. Obviously, you can see cultures influencing and economic policy, but as a matter of fact, we are quite on the same level. So I would like to, on behalf of IDP, to thank you all and appreciate the fact that you accepted our invitation. You managed to share with us your time, which we think which we know it's very valuable. We appreciate the fact that we were able to coordinate the time, considering that we are in different time zones. Very, very different, everybody. I think very much Elsa, who is awake at this time, sharing her experience with us. Thank you, Rita, for being with us today. Actually, Rita, it's a Brazilian, so it's a very good thing to have a countrywoman being practicing law abroad. Thank you very much, Adam, to share the U.S. perspective with us. With this in mind, I shall declare the meeting final, and let you know that soon we will have it uploaded at YouTube at IDP online page at 5 p.m. Brazilian time to a rerun of our meeting for more people see it, and we will send for the panelists a link for you to share with your colleagues, for them to have the opportunity to be with us also, and for everybody will have his timeline and will have the ability to see it again. So thank you very much. I would like to announce, since we have a foreign audience too, that we will have a magnum class from Professor Bruce Ackerman from Yale Law at next Friday. We will have it here at this same event. So it would be good for one who wants to see Professor Bruce talking. The event will be moderated by two Supreme Court justices, Brazilian Supreme Court justice, who will moderate the event with Professor Bruce Ackerman. We are glad to announce this too. So thank you very much to be here with us. Thank you very much again. Bye-bye.
Bye, everyone. Thank you.
Thanks. Thank you very much, guys. Bye-bye.
Bye.